Hello everyone, I'm Rick Carver, and welcome to the next segment of my story, A Travesty of Justice, and this is brought to you by the fearless Cecil County News. Today, I will walk you through the trial, some of the trial. I hope that this story will prevent what happened to me from happening to someone else. It isn't hard for property to be stolen from you. I will show you how it was done to me. Please bear in mind that all of the documents and testimony you're about to see have also been provided to the Maryland Insurance Administration, and the Maryland Attorney General's Office has reviewed them as well. At least I was told by Assistant Attorney General Timothy Lake that they were reviewed. It's hard to trust state officials these days. I found out. Cecil County State's Attorney James Delmeyer has these documents and files, and I'm still waiting on his decision whether or not to criminally investigate. If you're watching this, James, I'm still waiting for you to get back with me, or at least respond to any of the several messages that I've left you. All right, let me give you a quick review, but if you have not, please watch the previous segment in order to bring yourself up to speed with what we are starting with today. I filed a lawsuit against the Security Guarantee Corporation of Baltimore, as well as RBS Citizens Bank. The lawsuit was due to an illegal counterfeit deed of trust that was filed with Cecil County Land Records on July 22, 2010. This illegal, fraudulent re-recording killed a multi-million-dollar deal that included the sale of my business and farm parcels. The counterfeit deed of trust also stole 2 parcels of my land equaling over 60 acres. I've done my absolute best to come up with a way to walk you through some important details so that you can better understand how we put it all together. I have provided many more facts with a link below so you can take your time and read them at your leisure. These questions and answers are taken verbatim from court testimony. Not kidding you. This is verbatim. So let's get started with part 1 of the trial. The trial began in early 2017. Just as we walked into the courtroom, the new lawyers for RBS Citizens Bank made an offer to settle their part out of court. Now, this offer had nothing to do with actual money changing hands. It was at the time, though, it was something that we seen that was fair. So we accepted it. We got the impression that the bank really wanted to wash their hands of their problems. After the past few years of litigation, they just wanted to get the heck out of the building. I don't blame them. Up to the moment that John Kosogof from Security Title took the stand and began his testimony, we were still under the impression and belief that it was Friedman and McFadden, who was the law firm that represented the bank, were the ones at fault. They were ordered to shut down by federal and state prosecutors for mortgage scams and other violations in the middle of all this litigation. We at first believed it was this law firm that defrauded me and my family and caused so much damage. We figured that the title insurance company was somehow involved with them, so we proceeded with the trial. As we start reviewing the documents, please remember that the majority of John Kosogof's testimony was a surprise to us. It was the first time anyone heard this version, his version, of what he did and why. We never heard it before. His testimony made absolutely no sense to me, but ultimately it did provide me clues that helped me figure out the real truth. I'm going to bring them to you. The God's honest truth and the facts which support it differ vastly from Kosogof's words. The amount of evidence and exhibits we have to share are overwhelming. In order for everyone to follow and understand the correct progression of the trial without being bored to sleep, I will personally walk you through a handful of some important, blatant lies and misleading answers from John Kosogof. Now let me show you and demonstrate what we have put together. It's in these links for you so you can better understand and follow this vital information. I will provide a link that you will see below in the video description that provides you with these facts and so much more. Please remember and review them at your leisure. It makes my blood boil every time I look at them and go over them. It's crazy. We cataloged the trial points and documents as G1, G2, G3, etc. This way you can review the information we provided in the correct order. Every question and answer in this testimony was copied verbatim from the court transcripts. A few parts may be redacted simply to protect sensitive and sometimes personal information. This is how we have provided you in the link below with John Kosogof's trial testimony, and then the facts and truth below it. Enjoy. Now G1 will say the pages, the page and the line and numbers, or where to find the testimony in the complete trial transcript of John Kosogof's, and we're providing that. Okay, the beginning of John Kosogof's testimony. As you can see, page 82, line 21 through page 83, line 5, Dwight told me, his attorney, questioned, how did you become aware there was a problem with the title insurance policy and what the reason was? And John Kosogof answered. Counsel for it was Friedman and McFadden, and they contacted our office and submitted a claim under its policy, advising that they believed that the mortgage, or the deed of trust, was defective, and that they believed that all the property shown on the deed by which the Carvers acquired, which would have been the 3 parcels, although I think their letter referenced 4 parcels, should have also been encumbered by that same deed of trust. Well, you can see that right from the beginning of John Kosogof's testimony how false, misleading he is based on this document. This initial contact letter is in fact a notification to John Kosogof of Security Title that the bank is filing a title insurance claim against the policy. Now, as you can see this document, F1, and read for yourself from the actual contact letter, Kosogof's testimony does not match what the letter actually says. We never saw this letter. It's important to understand this. It was never provided to us and was introduced later in the trial by the bank. We didn't know any of this. It was all new. In this letter from Friedman and McFadden, they do not ask for anything more than a clarification of Book 1997, page 142 of the Deed of Trust. That's the Cecil County Land Records identification of where to find this. The legal description, which is the loan, and questions my wife's signature, stating the omission of her name may be a scrivener's error. This is in the letter. You can read it. We have it for you. This was the first time we ever heard anything about a title insurance claim being initiated by the bank. We're like, what the heck's going on? We never heard of it. Yes, I did start really wondering what is happening. I believe this was the very beginning of the cover-up and fraud Kosogof perpetrated on the court with the help of his attorney. You decide for yourself. Let's go to the next one. As you can see, page 88, line 19 through page 89, line 3 in the testimony, Dwight Tomey questions, what was the nature of the problem when you looked at your policy? John Kosogof answered, well, the claim came in where the lender believed they should have had a lien on all the property that was owned by the Carvers. So one of the first things we would do is take a look at the policy to see what we insured. And when I looked at the policy that was issued by Global Title, I noted that the legal description page was blank. So that unfortunately offered no guidance as to what was being insured. Well, here we have more false testimony, and it's designed to mislead the court. This is a very vital piece of the case, and for sure, of the fraud perpetrated. So, I just want to take a minute or two to take and explain. So when you review these documents in the links, the dots will start to connect for you. Okay? Remember, this testimony is from John Kosogof, and he's the underwriter for Global Title. And he is testifying about his company's issued, recorded title insurance policy that was part of the loan origination documents of my 2005 loan. The title insurance policy was worth $560,000. Might be some motive there. And was part of the loan's closing documentation. It was Global Title of Wilmington, Delaware, who was paid to do all of the document prep required by the bank and was part of all contracts at our 2005 closing. Global is an agent company for security title. This is the owner signature page for the title insurance policy. Now notice the top lists the property address, and at center it says for residential purposes only. Now these points are very important and will be brought up several times throughout. Remember, this is John Kosogof's company's policy. Why would he not have a complete copy of it to review, as he has stated above in his testimony in G2? And why would John Kosogof testify that his policy, which does have the legal description that he insured, is blank? There's a reason for it. I'm going to show you why. It's a riot. Hold on for a second and let me explain and make sure I connect these dots for you. You won't believe this, but it's right there in black and white. Yep, John Kosogof is right. This page is blank. Now ask yourself, if there was no legal description to the deed of trust, how could there have been a title insurance policy written for this title in the first place? Also, what John Kosogof is not testifying to is the fact that Global Title attached the actual 3-page legal description to the back page of this policy, of the insurance policy. This makes the policy complete and legal. And ask yourself again, without the legal description, how could you ever insure a title to begin with? Why was John Kosogof trying to hide the legal description from the court? He's able to continue misleading the court because the actual legal description page is blank, as you can see. So technically, he didn't lie to the court. That's how he got away with that. Here is the legal description that is part of the loan and is part of the title insurance policy. You can see them right there. You can take my word for it or review the documents I have supplied so that you can decide for yourself. H1 through H11 is the actual complete title insurance policy for you to review. The link's below. In reviewing the policy, you can see another piece of vital information. Notice that H4, Schedule B, Part 1. Look at B, which is highlighted. This lists documents of the minor subdivision by record book and record page number that's recorded in Cecil County records, land records, of the 3.5-acre parcel. Okay? Now please look at H8. This is the endorsement for the insurance policy. Right under the header it says, and it's highlighted in bold, void if insured land is not used or to be used primarily for residential purposes. Take a look at C1, which is my original deed of trust from 2005. The link is below, and this is important. Get a chance to do this. Please note that the first 4 pages you will see have the same legal description that is listed and is part of the title insurance policy. They're one and the same. Okay, now we have now established that the same legal description that is in the deed of trust is the same one the security title has insured and has listed in the title insurance policy. Okay? Although Kosogof's testimony doesn't acknowledge this, there's reasons why. Also, we established that the title insurance policy is very clear that the policy is for residential purposes only and that the correct address is listed. Furthermore, the minor subdivision information is listed in the insurance policy under Schedule B, Part 1. It's in the insurance policy. Now ask yourself this. How could John Kosogof change the deed of trust, which is at the center of this action, if he didn't have the legal description that he insured? Kosogof testified throughout the trial that he researched and examined all of these documents many times. If this is true, then why is it that he never noticed the legal description his company insured for $560,000 as part of the loan and all the supporting documentation recorded by their agent company Global Title is the wrong legal description? You heard me right. It is the wrong legal description altogether. He's never mentioned that, and he won't. Please review once more. C1. This, folks, is just one of the proverbial smoking guns proving the fraud and cover-up. Please take a close look at the 4th page of C1. Look at the left side halfway down the page. You'll read being parcel, the parcel number, and under that, total acreage 3.505. This listed parcel number and acreage is the correct collateral for the loan in question. All loan origination documentation lists this parcel and acreage only. No other parcels are ever listed on any loan origination documents whatsoever. However, Global Title incorrectly recorded a non-existent legal description and attached the correct information of the collateral for the loan. You see, folks, the 41-acre parcel incorrectly recorded as the legal description in the deed of trust for the loan Kosogof insured for $560,000 does not exist. It was never part of, nor was it ever intended to be part of, the loan. Remember that subdivision I was approved for in 1998 to build our home? That reduced this 41-acre parcel to a 37-acre parcel. This dissolved the 41-acre parcel. How and why did Global Title record it in the first place when it was not part of this loan? Not a single loan document mentions it or lists any additional collateral or parcels other than the 3.5 acreage. All 4 of my parcels have different addresses and tax ID numbers. Global Title screwed up really bad. Maryland Insurance Administration, you guys paying attention? Hold on now. This wasn't the only mistake that Global made and John Kosogof covered up. Are you wondering why John Kosogof hasn't mentioned anything about the 41-acre legal description mistake? Neither he nor his defense attorney, Dwight Tomey, ever mentions it in the trial. Never in the trial is it ever explained why the 41-acre parcel was even recorded, and the defense never asked the question. Are you starting to understand why it was covered up? But wait, I have more. Remember the disclaimers on the insurance policy regarding residential purposes? Remember the listed subdivision information? The entire defense, as you can read in testimony, it's all predicated throughout the entire trial that John Kosogof, in a good faith effort, that's Maryland Insurance Administration words, searched and searched for the elusive, non-existent 3.5 acre parcel. Well, there is a clue that it does exist, Mr. Kosogof, right there in your own insurance policy, H4, Schedule B, Part 1, under B, and it includes the land records recorded book and page number to help you. While you're at it, Mr. Kosogof, you could have asked your own attorney, who is defending you, for help in locating this non-existent parcel that you searched all over the place for. Why? Because in 1998, this attorney, Dwight Tomey, the defense attorney, was Cecil County's council attorney, and he approved this subdivision in the easement. You know, the one that doesn't exist? Go ahead and look closely, folks, at our link B6 and B7. There's Dwight Tomey's signature authorizing the documents of the subdivision. Are you asking yourself how this is possible? I know, I am. How is this not a conflict of interest? Now you might begin to understand what I believe to be the wool pulled over the court's eyes. There is much more to show you, including statements made in open legal argument during the trial where Dwight Tomey actually guarantees the parcel doesn't exist. Not anywhere in land records, etc. I have to ask because the title insurance policy clearly states that it was for residential purposes only. So how could they get away with adding 2 parcels to a policy that are not zoned residential? Doesn't John Kosogof void his own policy by adding 2 parcels that are zoned ag? In fact, Citizens Bank back in 2005, when I took this loan, they refused to give loans or use for collateral any unimproved or raw ground, such as farm ground or ag. Folks, I've got to ask you, are the dots starting to connect as far as the reasons this fraud was perpetrated? The myriad of false, misleading testimony from the defense is worse than it even appears right now. Take a look at page 90, line 7 through page 90, line 19. Dwight Tomey has a question. Did you get a copy of the loan origination file? And he answered, I'm not sure I got the entire file, but I did get the file, yes. Another question to him, did you review the documents that were sent to you? And John Kosogof answered, I did. And Dwight Tomey answers another question. Did that clarify what was supposed to be be intended as collateral for the loan? John Kosogof answers, well, the loan application stated was a refinance loan, take out various loans. I believe there were 4 previous loans secured by deeds of trust on the property. But other than that, John Kosogof says, there was nothing within the file to indicate that they intended to limit their collateral to a 3-acre or 3.5-acre parcel. That's from trial testimony, folks. These are just more deliberate, misleading statements by Kosogof. I have a link below for you to review, which has all of the bank loan origination documents, C2, 6, 7, 8, 9, 10, 11, 12, and 14. 14 is a copy of the State of Maryland Land Instrument Intake Sheet from the original deed of trust that lists the land used as collateral for the loan, the correct property tax ID, and location of the property being conveyed is clearly listed as my home address and the tax ID for the 3.5-acre parcel. Oh, and by the way, there is no such area in the contracts, any loan contracts, in any of the origination documents asking what I will or won't limit as far as collateral is concerned. Come on. We all know it's the bank that makes that decision, not the borrower. The defense has a good reason to be directing their examination in this manner. The above testimony is just a snapshot of the overall conspiracy. You can see something starting to take shape. Folks, this is truly a white-collar crime you are witnessing. Please realize that white-collar crime is complicated by design. There are normally multiple layers in order to confuse and convolute any truth and statements. We will together stay on the same track, connecting the dots. Please take your time and review the information linked below. There is more testimony in these links that are self-explanatory and sequenced correctly as the trial went on. You will realize the crime as I have while connecting those dots. In our next segment, which I believe may be the most important segment, I will explain why the defense is moving in this direction and illustrate the only true motive, the only really true motive behind their strategy. They can't explain any other one. I will give you the synopsis for the rest of the trial and link related documents and testimonies so everyone can get those aha moments. I promise they will be significant and plentiful. Connecting the dots will be easier as we move forward. When we follow up the future segments with more testimony, what I believe to be perjury will become crystal clear. The defense attorney makes statements in open court that are much more than simply a slip of the tongue. I thank you for your time. Remember to tune in to Cecil County News for more great content. Good night.